There's also the question as to who may file a complaint against a prosecutor or someone working under the direction of the district attorney's office, and whether or not the complaints are in fact sworn under the penalty of perjury like a complainant would be making in the criminal justice system. Those are some issues that we would hope that you would consider. The Commission would have unprecedented power to compel the district attorney to testify against himself or herself. And so another legitimate question, a legal question, would be whether or not the district attorney or the assistant district attorney would be receiving immunity for purposes of those complaints, which is often the case if we're compelling testimony from a defendant in the criminal justice system in the grand jury. One of the other issues that we're very interested in knowing is whether or not the Commission would be bound by the same evidentiary rules as we have here in the criminal justice system, and what the burden of proof would be to sustain a complaint against a prosecutor or an ADA. The other issue that I've had personal experience with, and one that I think is very, very important here, is whether the Commission, and I think you've answered it based upon the fact that you've stated that this would be modeled after the judiciary model, and therefore this hearing wouldn't be going on during an active prosecution. So I guess the question as to whether or not this Commission would provide additional opportunities for discovery that defendants would not be otherwise entitled to under the criminal procedure law. If it's happening after the prosecution, then I guess that issue is moot, if I'm hearing what you've just stated, correct? So this would
yes.
be, okay.
I mean, I could be rude and say that we could offer you the same kind of discovery as criminal defendants are offered in the state of New York by law.
That's not rude for me. That wouldn't be rude for me at all, sir. The other issue that I would hope that this body would consider is the issues with respect to identity and personal information that's contained in a prosecutor's file, that would not be subject to disclosure for purposes of putting out pertinent information regarding victims and witnesses. Those are things to be considered as you consider your commission. The other issue is whether or not this commission would take the place of the current commission in the 3rd Department that oversees conduct for prosecutors as well as all attorneys, or whether or not prosecutors would be subject to more disciplinary than an attorney with a defense attorney per se. And we would like to know that answer as well. Without getting into too many other issues, and I think some of them we've discussed here, currently as it stands, it's the executive branch that has the authority to remove a sitting prosecutor. And we were wondering about the constitutionality of the legislature usurping the authority of the executive in being able to remove a sitting prosecutor, and where the law that would support a legislative body from usurping the executive authority at this point. Also, one of the issues, and there's a lot of important issues that need to be discussed.
I think that I don't.
Yes. Just real quick to respond to your, the legislature usurping the executive. He does it to us all the time, so I don't think we have to be but
did I open up a can of worms?
But one of the things, I'm from Suffolk County, and obviously we've all read what's going on out there, and I'm going to let the process play out, but there's certainly a lot of bad allegations, and we'll see what happens in the coming months. But as a result of that, our county executive has demanded the resignation of our district attorney, saying he's running a corrupt organization.
No.
And he has said that he's called for the governor to remove him. And so they did a little history, and I think it's happened one time many years ago where a governor actually did that. So that may not be the answer we're looking at too. That does about as frequent as the
As a prosecutor being disciplined.
Exactly.
I just want to stop picking on the Bronx. You know?
6 months in.
We do enough of that in the association.
He's talking about the old Bronx.
Yeah, exactly.
So David, I just wanted to also suggest to you that your allegation, what you said about the usurpation of authority, the governor would make that decision because he'd have to sign the bill as to whether or not he or she wanted his power to be usurped in matters of this nature.
Thank you. The
Now,
last issue
may
that
I also
sorry.
just add to that is we are very much aware and took caution to not step on the powers of the governor. Final action, if there's a determination to remove a sit-in district attorney, would remain the governor's act, in the governor's authority. We do not propose a commission with the power to remove a district attorney, but the result of the investigation and the recommendation would go to the governor, and he would act under his constitutional authority in that case.
Okay. The other, and one final point that I'd like to make, and I know that there have been some comments about my colleague's reference to a chilling effect. There is a very realistic issue here that we have to deal with, and that is an assistant district attorney who starts off his or her career earning $50,000 to $55,000 a year, being subjected to the commission, and whether or not there are counties that believe that they should represent prosecutors, county attorneys' offices that believe they should represent, and then there are counties that do not represent their prosecutors. So there is that expense that we should also talk about, and if we're going to talk about that, whether it's there's something that has to be done by way of including language about that kind of support and representation in whatever this body decides.
Thank you. We have, thank you all for being succinct and to the point. I really appreciate it. David McCallum, the last person in the first panel, if you would please provide your remarks.
Sure, thank you. Good morning, everybody. This issue hits home to me in a very, very personable way. I think whenever we talk about prosecutorial misconduct, we're hitting at the heart of the criminal justice system when it comes to the district attorney's office in general. I wouldn't be sitting here if I, first of all, I would be remiss if I didn't mention that I would not be sitting here if not for a change in Brooklyn in terms of the district attorney's office when Ken Thompson took over. Mr. Thompson agreed to look at my case in a very different way as opposed to the previous prosecutors, meaning Charles Hines and Elizabeth Holtzman, for that matter. So I just want to be very, very clear about that. But I was sitting in prison for 29 years because of two legs of the prosecutorial misconduct. For one, there was an individual in my community who was a known informant, a career criminal, who we only found out decades later he was involved in some very, very shady operations with the law enforcement in my neighborhood. We also learned later on that this individual made deals with the prosecutor in exchange for his testimony. So this individual was allowed to testify falsely, we believe knowingly, by the prosecutor, who stood by and did nothing to correct this gentleman's testimony. As a result, we believe that contributed heavily in our conviction. And so when I say our, I'm talking about myself and my co-accused, Willie Stuckey, who unfortunately passed away in prison in 2001. So when I talk about this hits very, very home with me and it's very personal, I really mean that because Mr. Stuckey, in my mind, should not have been in prison in the first place. So when we talk about, well, I think one of the words that come to mind for me when you talk about an issue like this is transparency or lack thereof. There's no transparency when it comes to disclosing information and evidence and documents by the district attorney's office. From my experience in doing my research in prison, I learned that the prosecutors, not all of them obviously, but some of them at least, they really talk a good game when it comes to evidence that's stored and evidence that's not disclosed. So we are led to believe, and we're at the mercy of these prosecutors. So I should just remind this panel, we're at the mercy, meaning myself and people like Mr. Katibi, is at the mercy of these prosecutors because we have no way of knowing what's available and what's not. And so for me, I think one of the ways that we can sort of, help out that situation a bit is at least, work towards this real transparency that I'm talking about, is to hold in-camera inspections of documents, prior to the case going to trial, for that matter. So, for example, if the prosecutor gets a hold of information that's helpful to the defense, he or she should be obligated to turn it over to the judge for an in-camera inspection. That way, the defendant and his attorneys, of course, will have an opportunity to vet this information and this evidence and these documents out to see what can be useful and what can't. But that doesn't happen in today's criminal justice system, and I think that's sort of like a black hole. It's really a black eye in the criminal justice system because as long as these matters,
I just want to correct you, sir. I want to correct you to tell you
Sure.
that it does happen in our criminal justice system, just not in New York and a few
Oh,
other
yeah, so let me be
states.
more specific. I just don't, obviously, I just don't,
No,
just don't talk
you're
about
right.
New York
I just
State.
wanted to let people aware because the general public is not aware of it because they watch Law and Order and they think that discovery, open file discovery is the law of the land,
Yes.
but not in New York.
Okay, well, yes. so-
It is in Albany.
Yes.
But that's by the grace of the district attorney who's presently serving, is it not? Thank you.
Okay, thanks for that tidbit there. I appreciate that. So as far as I'm concerned, and I don't mean to speak with anybody other than the case that I'm here to represent, which is myself and Willie Stuckey, that prosecutorial misconduct is a very serious issue to me, and I just think if something seriously is going to get done about this particular issue, it really has to happen today, and it starts with this hearing here. So for me, just to be able to discuss this issue and just to talk about why this happened. I think these are questions that are sometimes not really answered. They're parroted in some ways, but they're not necessarily answered. I just think that's unfortunate, and I think we, as a panel and as an area, need to sort of get to the bottom of this particular issue.
Thank you. With the consent of the other panelists here, could any problem in those that haven't spoken come forward and those that sit back there? And then at the end, if we have any questions of anybody, we can do it at that time?
Great idea. Thank you.
Okay, can we switch seats there, except for the Bronx DA, the new Bronx DA?
Unbelievable. To listen to this, you're going to cry.
The technical stuff. Technical stuff.
Looks like you're getting ready to try a case with all that stuff you got with you. Look like you're ready to try a case with all your briefcases. Okay. Okay, I'm not sure exactly who is who, but what I'd like to do is start off like we did the last panel with the Office of Court Administration, and without, I'm sure you have some remarks that you had in mind. Stephen Downs, past Chief Attorney of the Commission on Judicial Conduct for 28 years?
28 years.
I think the thing that's most interesting to me, and you can go on and expand on other things, but what I want to get in your testimony, whatever point you want, what the experience was in the outset of the commission and how that evolved as far as the public perception of it and the judge's perception.
Right. I'm glad I'm following Bob Timbenchin because we've been colleagues for many years with the commission, and he gave very good description of how we began. I was a little bit before him with the commission. I was literally in on the door. We spent a week sitting on the floor waiting for the furniture to arrive. But the creation of the commission itself arose from a kind of a crisis of confidence back in the early 70s. Jack Newfield had published an article that sort of described the 10 worst judges in New York, and it sort of fed a public perception that there was no effective discipline for judges, and that judges were free to engage in any misconduct. So that is really a lot of the impetus that brought the commission together. At the time, there was a lot of opposition from the judges. They said this was going to interfere with judicial independence. That was the big thing. And I think after a couple of years, we began to get feedback from the judges, and their feedback was exactly the opposite. They said, you know, actually, this enhances our independence. And I just want to give you one example of how that happened. At the time, we got involved in a investigation of ticket fixing. There was a practice in upstate New York particularly of one judge sending to another judge a letter on judicial stationery asking for favors for constituents. And at one point we had 250 judges under investigation. And when this all sort of came out, the judges began to say, you know, in our situation, we got a lot of pressure from politicians, from people of influence, and we thought we had to do this. We thought this was part of the job. Now, because the commission is there to enforce the rules, we have been made independent. We can say, no, we don't do that anymore, and we are free to do our job. And what I think would be true, this is true of any professional, because all professionals are under pressure from time to time to cut corners, to give favors to the well-connected, and if there's no enforcement mechanism, you're just forced to do things sometimes that you think are not right. Now the prosecutors can say, sorry, we don't do this anymore. We're not going to rush a prosecution when we're not sure we have a case, just because you want that. We have our ethical obligations, and they are enforced, and we're going to stay with it. So in my sense, I think this kind of a commission actually enhances prosecutorial as well as judicial independence. And I wanted to just say that I think one of the advantages of something like the Commission on Judicial Conduct, and I've been very proud to be associated with it over the years, was that it was a model of litigation. That is to say, it didn't just give due process. It tried to give to the judges that came before it a model of what really good due process litigation would look like. And I just happened to have been a lawyer on a case involving the Commission on Judicial Conduct, and I was very impressed at the time that they gave me all of the discovery that I was entitled to very promptly. They cooperated with everything. They made it a pleasure to be a part of litigating. And I think that kind of a model is good, particularly with prosecutors. You don't necessarily want to be prosecuted as a prosecutor with the same standard that a lot of defendants get when they get into court. I just want to say a few comments quickly about the Commission on Prosecutorial Conduct. One of the big features of this model is that it is truly independent, and it is perceived as being independent by the public. And I think that is necessary to develop credibility. The present system, which, as you've heard, is private, it is clubby, it is done within a small group of people, and it is not perceived as independent. And so its results, whatever it does, is not going to be credible, no matter what would be done now to change it. One of the composition of the Commission on Prosecutorial Conduct is particularly important because under the statute, it requires that all of the players in the criminal justice system, the prosecutors, the defense bar, and the judges, are present on the commission and can engage in the kind of creative discussion that is going to lead to a very progressive way of disciplining prosecutors. This is not going to be the kind of closed system where the prosecutors dominate and so nobody gets publicly disciplined. The legislation provides for a direct appeal to the Court of Appeals. This was very essential, in my view, to the success of the Commission on Judicial Conduct, because that gave the Court of Appeals the ability to speak on the kind of judiciary and the kind of criminal justice system they wanted. When the Court of Appeals upheld what the Commission did, it very much strengthened its hand. It made it appear to be the kind of real oversight body that it was. And when the Court of Appeals disagreed on those rare occasions with what the Commission on Judicial Conduct did, it essentially indicated that there was oversight over the Commission. So it reassured the judges that they were not dealing with a commission that was exercising arbitrary power. I want to also just...
do you believe that it had any kind of a chilling effect on the operation of any judicial?
No, I think it actually enhanced it, as I've said. I think and I've heard from a number of judges to say, we are now proud to be judges. We feel we have been given independence. The real problem, for most people is not living under the rules. The rules are not that hard to live under. The problem is resisting people who want you to get around the rules and change the rules and do things that are not there or shouldn't be there. And that's what the Commission is set up to prevent. And so it makes it much simpler. Now you don't have to deal with all these other issues. You just follow the rules. In my view, I think that is just a much simpler, easier way to deal with your profession. And I wanted to make clear that the grievance committees, as I understand it, and Bennett Gershman is really the expert on this and can tell you more if you want to know more, but my understanding is that the grievance committees basically do professional standards, and there's not a great deal in the professional standards that deals specifically with prosecutors. There are a number of other codes. There's case law, and there's also the ABA standards for prosecutors, which are much more complete, but that has never been adopted officially in New York. The present legislation does adopt that, and so it gives the disciplinary body, or the Commission on Prosecutorial Conduct, a much broader and more complete picture of what it means to be a prosecutor and the kind of rules prosecutors should follow. And I also have to say that one of the last thing, and I'll just quickly wrap up with this, the Commission on Judicial Conduct for years published an annual report, and in that annual report, they commented on various things that they had discovered that needed reform. And over the years, a number of reforms were adopted. And I assume that the Commission on Prosecutorial Conduct will do the same, that they will find things in our somewhat antiquated prosecutorial system that need improvement or updating. And they can make those recommendations, and in the process, I hope, slowly bring about in New York State an adoption of best practices. We have a very fractured and decentralized prosecutorial system, and getting the word out about what are new innovations, what are better practices to follow, is a very slow process, and hopefully this is something that the Commission could advance. So with that, I'll rest and take questions if anyone has any.
Okay, thank you. Next, it's a Darcel Clark,
Yes.
former judge, now the District Attorney for Bronx County.
Good morning, and thank you for this opportunity to appear before you on this very important matter. Yes, I am Darcel Clark. I am the current District Attorney of Bronx County, newly minted, I guess you would say, in office for 6 months. So anything that happened before that, you can't blame it on me. But at the same time, because it was my office, because it's part of the history of the District Attorney's office, does not mean that I'm going to ignore the things that have happened in the past. By far, one of the things that I am doing is, as I'm going through the office and doing a number of reforms, I have to learn lessons from some of the things that happened in the past. I just wanted to give some other incidents where prosecutors have been held accountable for the conduct that they have. I have a number of cases here. Hayter versus the Committee on Professional Standards, a third department case in 1982, where a prosecutor was censured for their conduct. Brophy versus the Committee on Professional Standards, a third department case from 1981, where that prosecutor ended up being convicted in federal court of a misdemeanor of depriving a person of their constitutional rights based on the work that they did in the office. That person was ultimately disbarred, but then it was overturned, and later they were censured. In 2011, in Ray Muscatello, second department case, where the prosecutor there, Assistant DA, received a 1-year suspension for going before the grand jury with a blank chemical test in a drug case, and indicating to the grand jury what the results were, even though they weren't on the test. And that prosecutor knew what the results were, but from other evidence, not the evidence that was presented before the grand jury. So that person was censored and then ultimately received a 1-year suspension from practice, was later reinstated. Then I have another case in 1990, a Fourth Department case, Curtis Lyman versus the Grievance Committee, 8th Judicial District, where this particular assistant DA represented clients while simultaneously prosecuting those matters as a DA. So the person was a DA, but at the same time was representing clients. That person was censored as well. So I don't think you can say that the system that is in place doesn't work. And yes, I have another one, In Ray Ross from a First Department 2000 case, a joint disciplinary proceeding against the ADA and her husband. At the request of her husband, he tried to use her position to undermine a traffic summons, and she got fired. Conflict of Interest Board fined her $1,000, and she got censored. I actually know these particular individuals because I was in the office at that time. So the present system can work, and there's just a fundamental misunderstanding of the existing systems. Prosecutors are held accountable for their wrongdoing. We have internal trainings, ethic policies, judicial oversight during trials, the appellate process, and the grievance committee procedure. All of those things hold us accountable. Internally, I can tell you, as a new DA, I can personally tell you that prosecutors now are working really hard to train their assistant DAs to meet every disclosure obligation required. District attorneys are going beyond the law and disclosing the information that needs to be turned over. Look, we read the papers. We know what the present climate is. It's not easy being a district attorney these days, but we do have a job that we have to do. And we know the complaints of the public, and we know how you feel as the legislature. But through the efforts of the District Attorneys Association, which I am here to represent as well as the New York Prosecutors Training Institute, NIPT, we across the state are meeting, we're creating best practices and ethics networks through publications called The Right Thing. I think we sent that to you, Senator, and the Assembly as well, which is a book we distributed statewide that talks about the best practices and the ethical obligations of assistant district attorneys. But so we're not ignoring it. And I think that you will see now all across the state, new district attorneys are being elected, like myself, that are willing to do and are doing the right thing as frequently as possible. Last week, the Putnam County DA consented to overturning a conviction. I've been in office 6 months. I've done it at least 2 or 3 times. District attorneys are different than they used to be in the past. And we are turning the corner, and I like to say that we're turning, the right corner to make sure that we're doing our obligation. You have to realize that this is an adversary system, and we have to be able to do our work without fear or favor, and that's what we do each and every day. And with these court proceedings with the Brady rules and Rosario and Giglio, we are constantly reminded of the things that we have to do. I talked about the voluntary discovery practices, voluntary discovery. My office goes beyond what is required in the statute 24020 to make sure that we turn over. Defense attorneys, when they're preparing their cases, they ask for discovery and they make sure that they tell us what they need if they don't think they have what they've got, what they need. In the trial courts, the judges are the gatekeepers, and they're at the bottom line to ensuring that there's a fair trial. And if assistant district attorney gets out of line, the judge has every opportunity and the authority to stop things before they go wrong. If the argument is inappropriate, you could tell the jury to disregard it. If they keep doing it, the judge can declare a mistrial. The judge can keep evidence out that doesn't belong in. We're constantly being checked throughout the process, the criminal justice process, leading up to and during the trial. Again, if the prosecutor fails to disclose evidence, there are sanctions for that. disregard evidence, adverse inferences. Again, all ways to make sure that we do the job properly. And then on appeal, of course, judges review the prosecutorial errors in the appellate division, and we're reviewed as to whether or not we did something wrong. And with the appellate division, which I know firsthand, having been a member for 3 years of the appellate division first partner, the appellate division has the power not only to look at the errors that happened during the trial or errors of law, but they also have an interest of justice power, which not even the Court of Appeals has. So even if something wasn't preserved for argument, for appellate argument, the appellate division has the right through the interest of justice power. There's also a number of ways that defendants pursue their claim of prosecutorial misconduct. There's motion practice. They can move to set aside the verdict under CPL 330. There's a motion to vacate the judgment under 440. Defendants have appeals as a matter of right. They have appeals as a matter of the court's discretion. And of course, there's writs of habeas corpus in the federal courts. So there are a number of ways that, we have checks and balances on prosecutors. But win or lose, anybody can file a complaint with the grievance committee against a prosecutor. And I would say that we could be easy targets at times because, trust me, when we do our work, there's always an unsatisfied customer, unfortunately. But we're trying to do justice, and we're not always going to be popular.
Welcome to our world.
Huh?
Welcome to our world.
Yeah, exactly. Well, I mean, anyway, I'll leave that alone,
No,
yes.
thank
But anyway, we can be censured, suspended, or disbarred, because remember, you have to remember that prosecutors are attorneys. Setting up a separate commission, that means that, there are going to be two systems in place. This could go one way. Somebody could make a complaint through the Prosecutorial Conduct Commission, and that commission can come up with one recommendation or finding, and if they're also subject to the disciplinary committees or the grievance committees, can go through that channel and something else. Who decides? How do you know which is right, and why should we have to be subject to two different systems when there's one in place? I mentioned that there are cases where prosecutors are held accountable. And before I became DA, of course, I told you I was in the appellate division. I sat on panels of appeals where there were mentions or allegations of prosecutorial misconduct. And I could tell you, we ruled against and made determinations on the conduct of prosecutors in those cases. And I sat on, a number of reversal cases because of that, and defendants received new trials. At the same time, as a member of the appellate division, as an associate justice, we are the ones that hear the recommendations of the disciplinary committees and determine what sanctions, if any, there should be against a particular attorney, whether it's a prosecutor, a defense attorney, or any other kind of attorney. And I know that firsthand because I've sat on those panels and made determinations on whether or not somebody should be censured, public censure, private, disbarred. That is the power of the appellate division. So those things are there and in place. And besides the grievance committees, of course, and we talked about some of these things already, that the governor has the power to remove a district attorney. And of course, the Bronx knows that very, very well also because Governor Pataki did that very thing against Robert Johnson. We know that the media is constantly watching us. In this day of 24-hour news cycle, we're always being watched. So we know that somebody is always watching. And of course, the electorate can vote us out. That is what happened in the Bronx. 27 years Robert Johnson served, and I now sit here as the new district attorney. So, we are doing things, and of course, this legislature has the power to do many things. You enact the laws that we have to follow in doing our prosecution. So, we have to follow that law, and our assistants are also answerable to us as the elected district attorneys. And we demote prosecutors, we require training, we provide remedial guidance, and terminate employment if necessary. So this commission, I know, was modeled after the Judicial Conduct Commission, which I am also very familiar with, having served as a judge in this state for 16 years. So I'm familiar with that process. But one thing we have to remember about the Judicial Commission, I think part of when they started, you have to also remember those rules are necessary because some people sit as judges in this state who are not lawyers, which means that there needs to be some type of oversight of those types of judges, because the other members of the judiciary are lawyers and are subject to the disciplinary process, and the judge is now under the Judicial Commission. So there's constantly a need for, some oversight where there is none. With prosecutors, there is some already because of the fact that we are subject to the grievance committee. I just have a few more things. There is room for improvement.
Excuse me, when you were on the appellate division, did you have a red light? When the lawyer was talking too loud? Okay, let's assume we have a virtual red light here, okay?
All right. I'll wrap it up then. There's, the Justice Task Force has made a number of suggestions that can help the current process. And I think some of the things that need to be done are, for example, for the courts, there needs to be a distinction between error and misconduct. Okay? I think that just because district attorney or assistant district attorney does something does not mean that it's misconduct. It could be error, and the courts need to distinguish that better in their opinions. The court should refer to the disciplinary committee anytime that they find some type of misconduct of a prosecutor or a defense attorney. They need to refer that to the disciplinary committees, and that's not always done. As far as disciplinary committees, some things can be improved there as well. They need to collect the data. Senator DeFrancesco, we met with you earlier this year, and we talked about the data collection, that there's not enough data determining whether or not there have been allegations against prosecutors specifically before the grievance committee. And I think that what they need to do is make sure that they delineate prosecutors when doing their collection of their data. Again, the annual report that is put out by the disciplinary committees, they should determine the outcomes of the cases that are brought against prosecutors and what happens. The DA should be notified about any, disciplinary committee decisions. And of course, the most important is public education, because the public needs to know that there is a way for them to make their complaints. Lastly, as far as prosecutors, we're doing training all the time. Best practices, ethical procedures. In my office in particular, I'm telling you, because of things like this possibility of the Prosecutorial Conduct Commission, because of the best practices, because I'm a new DA and I'm overlooking all of the ethical challenges that we face as prosecutors, I'm setting up a bureau for professional responsibility that will have a best practices committee as well as an ethics committee. So we are constantly training and retraining and doing whatever needs to be done, even if it means firing an assistant district attorney if they fail to follow the rules. So, I think in conclusion, I think that we don't have a need for this commission. I think there are a number of things that are already in place. There could be room for improvement, and I'm looking forward to your questions.
Okay, thank you. Could you get the members, or get me, and I'll get it to everybody else, a citation for each of those cases?
Yes, I will.